Hey guys, and welcome to today's second video. The first upload had some loud music at the beginning, so I'm re-uploading it without that mistake. Today, we have 3 sovereign citizens in court. The first is a follow-up, while the other 2 are new cases. I also won't be interrupting the clips this time. Sorry about the first upload, and thanks for watching. Let's begin.
Mr. Smith. It was an S.
Good morning, Your Honor.
Good morning, sir. My understanding is that you are choosing to represent yourself, correct? You're choosing to represent yourself, correct?
I am pro se with advisory council.
Okay.
Yes, ma'am.
Did anyone give you information as to who that advisory council was going to be?
When I called, at the time, they hadn't been appointed.
Okay. Do we have a list of who accepts advisory appointments? Okay, well, we'll go ahead and appoint him, and I'm going to be perfectly frank with you. The list of attorneys who accept advisory appointments is, it comes through the kind of the Office of the Public Defender. And there aren't as many attorneys as there used to be who are willing to accept advisory appointments. I do have an attorney who has been willing to accept appointments before. However, I also know that in the next few days, he will find out if he's been appointed as a county court judge. But I'm going to appoint him at this point in time. And then at your next court date, we will give you information as to whether or not he remains your attorney or whether we find out who that advisory council is going to be. Okay?
Sounds good.
Okay.
I'm
sorry.
Go ahead.
I just want to go on the record real quick.
Okay.
Okay, so I am Gregory C. Smith, Jr., appearing sui juris under the mandate of Article 6 of the United States Constitution. Pursuant to UCC 1-308 and Colorado Revised Statute subsection 4-1-308. I reserve all my rights under the United States Constitution, including the 8th and 14th Amendments. Colorado Constitution, Article 2, subsection 7 and subsection 20, the United States Code, and Colorado Revised Statutes 18-1-504 and subsection 18-6-800.3. I acknowledge the appointment of advisory counsel to assist only in procedural research and technical filing. I remain the lead inquisitor and authorized representative. This appearance is restricted to challenging jurisdiction and procedural defaults and does not constitute a general appearance or consent to the court's jurisdiction of my private person. And I'm here to address the following, which would be the sufficiency of probable cause, specifically regarding the knowing element, the domestic violence designation, Rule 41E, property concerns, bond and protection order conditions. Because this is a felony trespass charge, I assert my right to a preliminary hearing under Colorado law. The charged offense requires a knowing unlawful entry under CRS 18-4-502. The state's own evidence shows I produced a key, identified my mail, and handling my belongings openly. That conduct is inconsistent with a knowing unlawful entry and instead reflects a claim of lawful access. I need to note for the record that both CSPD officer and the magistrate during advisement expressly found that there was no forced entry into the residence. CSP arrested me based on a name match and treated property in the residence as belonging to another person, creating confusion as to the identity of the person actually alleged to have committed the offense. I had a key to the residence, received mail there, and am married to a resident of the home. I understood the protection order applied to my stepson, but not the residence. The state initially pursued a violation of protection order and declined that charge That decision reflects the absence of evidence that I knowingly violated a restriction. The same knowing element is required here. Also, the advisement was conducted by video while I was in custody, and I was not provided any meaningful opportunity to consult privately with counsel. I was in a shared custodial setting and could not communicate confidentially. That impaired my ability to understand the proceedings and protect my rights under the 6th Amendment to the United States Constitution and the 14th Amendment to the United States Constitution. But I'm not asking to invalidate the proceeding, but I am asking the court to, hold on one second here, to take that limitation into account when evaluating the reliability of the process and the current posture of the case. I move to strike the domestic violence designation per CRS 18-6-800.3. This designation is factually unsupported as there was no physical harm, injury, or verbal threat. Regarding the property, I move for an order under Colorado Criminal Procedure Rule 41E, wherein the officers conducted a warrantless transfer of my property to a non-owner and restrained party without providing an inventory or receipt, violating due process. I request a full accounting and the immediate restoration of my belongings. If such an accounting cannot be provided, I move for damages in the amount of $5,000. Finally, since the court previously found no forced entry and the VPO has been dismissed, the basis for the current bond and the trespass charge is void. I request the immediate conversion to a PR bond and release of my funds. And based on those factors, I respectfully request dismissal for lack of probable cause.
Okay. Let's start first things first. Given the nature of the charge, which is a Class 6 felony, and you are out of custody, you are no longer entitled to a preliminary hearing. A lot of what you have addressed is factually based that would be determined most likely by a jury at the end, if we get to that point, setting the matter for trial and having a jury determine whether or not the alleged facts were done as an act of domestic violence, which, just for the record, goes beyond just an actual act of violence, but include acts done as methods of coercion, control, or retaliation. And so whether or not the domestic violence tag applies would be determined by a jury if in fact this matter is taken to trial, with a specific interrogatory being asked of the jury to find that the prosecution has proven beyond a reasonable doubt that any act constitutes a act of domestic violence. As to the factual basis, as to whether or not you believe the charges support the allegations that have been filed against you, again, you are not entitled to a preliminary hearing. A judicial officer has already made a determination that there is probable cause to find that you did the acts as alleged. And again, to the extent that you are either not offered or choose not to take any plea agreement, that would be addressed by a jury as to whether or not the prosecution has proven beyond a reasonable doubt that you committed the charge of trespass as a Class 6 felony. With regard to any evidence that was secured by law enforcement, to some extent, that may depend on as to whether or not such evidence or those items were secured and are going to be used as evidence in the case. I just don't know enough about this to know otherwise. So what I'm going to do at this point in time, noting that you have preserved all your objections, is I'm going to set this matter for a dispositional hearing, unless you're wanting to enter a not guilty plea today. I don't know. But my suggestion would be is that you spend a few moments speaking to Mr. Libby. He can advise you as to how you can get the discovery, the evidence that the prosecution has against you, that you can go over to the district attorney's office to get that information. And then also at the next court date, we will know who specifically your advisory counsel is, and they can also further advise you as to how to proceed in this matter procedurally, noting that if you take the matter to trial, you would have advisory counsel with you. But again, as you are aware, they would just be advising you procedurally how to go forward. You would be the individual who is actually conducting the trial. So we'll give you a new court date here in a moment.
And you said the preliminary hearing was, I couldn't have one.
You're not entitled.
Not entitled to one because of what now?
Because of the element of the charge and because, or the, I should say, the level of the charge, and you have bonded out. If you remain in custody, you are always entitled to a preliminary hearing. It changes a little bit once you have posted bond. But I'm going to give you a new court date here. And then we're going to set that about 4 weeks out. And if you just want to spend a few moments speaking with Mr. Libby, unless you already know how to get your discovery.
Prince Pugh, state, would you please start the record?
Yes, Your Honor, thank you. This is State of Indiana versus Prince Pugh. The cause number is 64D012305, ISO F54448. Defendant is present in court in person by video conferencing, is here with counsel, Mr. Steve Provost, State of Indiana by Gary Gurman.
I think it's an F6 though. That's just a typo. It's definitely 2305 F64448. Morning, Mr. Pugh. Can you hear us okay?
Yes.
Okay, thank you. Mr. Provost?
Your Honor, I don't have anything new to report to the court. I haven't been able to see Mr. Pugh since he was rearrested on this matter. However, I have reviewed the pleadings that Mr. Pugh has filed, and I guess I'm looking to get some clarification from the court and Mr. Pugh as to my office's involvement in this matter, Your Honor. From what I've read, it appears Mr. Pugh is desirous of representing himself in this matter and has filed his own pleadings in accordance with that desire. But I want to be clear if in fact that is what he wants and if my office should be withdrawing from this case.
Well, what happened was I entered an order striking some pleadings back in November. There were some more pleadings that were filed. I struck those in last week. And then there were some more pleadings filed, and I have a motion, or an order rather, that strikes those. But while it was in the work queue, some more motions came in. So I needed to work on the order to strike the additional pleadings that came in. We don't allow for hybrid representation in this court, Mr. Pugh. So I've appointed counsel for you, and you need to file anything that would come to the court has to come through counsel. You can't file things on your own, sir. You understand that?
No, I do not understand that.
Okay, well, that's how it is. So anything you need to file has to come from your lawyer. And if it doesn't come from your lawyer, I will strike it from the record because we don't allow what we call hybrid representation. Okay.
I object.
Okay, we'll note your objection for the record, sir.
Your Honor, do we need to have any discussion with Mr. Pugh on whether he wants to proceed pro se?
I don't have a motion from him to proceed on his own and without counsel.
May I ask, I understand you're not going to address it today, Your Honor, but just so I'm clear.
I mean, he hasn't filed that motion.
Yes, I filed a motion for a special appearance.
Yeah, that's meaningless to me, sir. And I struck that from the record, so it's of no moment.
Indeed, I object.
Noted. So I'm just going to set you over, Mr. Pribble. Is that what you need?
Yes,
Some more time?
Yes.
My Honor, are you aware that the respondent is a national citizen to the United States of America Republic, which is a sovereign government that has its own jurisdiction? Is the court aware of that?
Nasir Brown. Good morning. Are you Nasir Brown?
I'm not hearing today. Special appearance.
I'm sorry. Speak up so I can hear you.
Here today.
You're appearing here today?
By special appearance.
Okay. What is your name?
I'm a third party intervener on behalf of artificial legal entity, Nasir Brown.
Okay. At one point in your,
And I'm talking about the chamber.
at some point in your life prior to being this third party, were you Nasir Brown?
No,
You're not him.
I'm a third party intervener.
So here's the thing, if you don't tell me your name, I'm gonna put you in custody for not cooperating this morning. I'm not gonna, hold on. I understand what you're doing and what you're trying to do. It's not gonna help you a single bit in court to try to play these games.
That's relative.
So are you Nasir Lewis Brown, or have you been him at some point in your life or not?
Yes.
Okay, so I'm gonna call you by Mr. Brown because I'm not gonna say all the words that you just said, because you have now identified yourself as Nasir Lewis Brown. And so, Mr. Brown, this is, nope, listen, this is your initial appearance and you have 2 cases. And cause number 26, I just asked you not to speak over me. So here's the thing, Mr. Brown. I'm gonna be very patient.
And at the child subject matter jurisdiction, going on record.
Your challenge of the subject matter jurisdiction is overruled. Let me go through what I need to go through, okay? So this is your initial appearance, your first day in court. I'm required to go through what you're charged with by indictment. In cause number 26, DCCR 03322, you're charged with a 3rd-degree felony offense of assault family violence by impeding breath or circulation from February 16th of 2026. And then in cause number 26, DCCR 0323, you're charged with the state jail felony offense of injury to a child, and that's from February 16th of 2026. And so since you have made bond and got out of jail on your cases, have you had an opportunity to try to hire a lawyer? Speak up so I can.
Up and down.
It's been up and down?
Yes.
Okay, so here's what I'm gonna do, Mr. Brown, is I'm just like everyone else, I'm resetting your case about 30 days to give you some time to try to hire a lawyer. You need to try to get someone hired before the next court date. If you do, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? I'm sorry?
Overstand.
Say it
They
again.
overstand.
You overstand?
Yes.
Okay, what does that mean?
Overstand.
Do you understand what I'm saying, sir?
I'm blind.
You'll oblige.
I'm blind. Yeah.
Okay. You just determined to use different words and be difficult, aren't you?
No.
Okay. So as a condition of your bond, did you have a condition that you were not to have any contact or communication with the complaining witnesses in each of these cases, right? Okay, and so I want to make sure you understand the importance of that. And that if you do have any contact or communication with either of them, it would be a violation of that bond condition. If I find out, your bond would be raised and you would go back to jail. Do you understand that as well?
Overstand.
You overstand.
Same thing.
I'm going to guess that overstand is even better than understand. So you definitely know what I'm talking about, right? So we don't have any miscommunication today. You know exactly what I'm talking about. So I'm going to have you step in front of the clerk. You're going to sign a reset notice so you know when to be back in court, and take care of those things before the next court date. All right, step in front of the clerk.
Compliment you on your ability to not go off on the defendant this morning right out of the gate. That sovereign, I don't know if he's a sovereign citizen, whatever.
Hey,
Again,
he's just a wannabe.
Yeah, judicial temperament.
I appreciate that.
I wouldn't do
Short.
Okay.
The short ones right there.
They test that temperament.
You understood.
You know what, though? We decided after court that that's actually better than understanding. I mean, there should be no miscommunication or anything like that, misunderstanding. If you, because you overstood,
Understanding.
right?
Let me ask Maritime. You understand? I tell you everything you're going to say. You have any questions? You understand everything I've gone over with you?
I know.
They got to say something. I guess he understood. He didn't overstood.
Apparently, even lawyers and judges have heard enough sovereign citizen and American state national arguments that it's become a joke to them too. All right, guys, that's the end of today's video. I'll be following up with these defendants and the others I've covered before. If you liked the video, hit the like button. If you disliked it, hit the dislike. Don't forget to leave a comment and subscribe with notifications on so you don't miss any of my content.